Hi everyone, welcome. My name is Rosa Delgado. I'm here from the DePaul alumni group and one of the group members of it. And today we're hosting social media's protected activity. When can posting on Instagram can get you Insta-fired. Thank you everyone for joining us today. I'm gonna introduce from our DePaul first, Jessica Cruz from DePaul Labor Leadership, and then we'll go ahead and get started into the session. Jessie?
Yes. Hello everyone, hola todos, welcome. So thank you, Rosa. We're very glad to be hosting another alumni meeting today. As you all know, it's the mission of the DePaul Labor Education Center to serve as a resource for students, labor activists, academics, and community leaders seeking for a deeper understanding of labor issues and tools, again, economic justice for poor and working class people at our center. We also challenge everyone to consider what else must be done. And I think today it's going to be a great meeting because it's new times. It's also new workforce and also new rules that we need to follow. So I'm very excited to be here, and I'm going to pass it to Rosa so we can get this started.
So today I'm going to give a little background to our presenter, and we'll let her get started. Her name is, I keep wanting to say Eliza, but Elisa Reddish. She's a staff attorney at SEIU Local 73. She is a 2015 graduate of the UC Berkeley School of Law. She has been practicing union-side labor laws for 6 years now. First, she started as an associate at Cornfield and Feldman LLP for nearly 4 years, and then as an associate at Jacobs, Burns, Orlov, and Hernandez LLP for a little bit over 2 years. She has presented for the DePaul Labor Education Center in the past, and she's excited to be back. So let's give her a nice, warm virtual applause.
Hi, thank you so much, Rosa and Jessie. I'm very excited to be speaking to you guys. I love the DePaul Labor Education Center. I think it's a great organization and has great programming, and so I'm really excited to be here. So I'm going to share my screen. Just give me one moment. I'm gonna share my PowerPoint here. Okay. All right, so I'm gonna get started, and then I'm also going to just heads up that towards the end, we'll make time for questions. And you can, in the meantime, if you want to put stuff in the parking lot or in the chat, that's fine. I may or may not see it, but we'll get to it at the end. Or if it's something I don't know the answer to, I'll get back to you and just give me your email, and I'm happy to chat. So as Rosa said, I'm Elisa Reddish. I'm a staff attorney at SEIU Local 73. And today I'm going to be talking about social media as protected activity, or as I like to call it, when can posting on Instagram get you Insta-fired? So as everyone knows who does not live under a rock, social media and various social media platforms have proliferated over the years, which creates, exciting opportunities for workers to advocate for themselves, for their coworkers, for other workers around the globe. But it also creates opportunities for employers to surveil employees and to then end up disciplining or discharging workers based on their social media posts. Particularly during the pandemic, when everyone has been staring at their phone all the time and looking at and posting on social media, these issues are continuing to come up, and they will continue to come up in the future. And so it's a really exciting time to learn about this. So I thought I'd start with just a real world example of employees posting on online and getting fired for it. So this is a prominent example that some of you folks may have heard of. So back in March of 2020, when the pandemic was just beginning, at least here in the United States, a bunch of Amazon warehouses were already underway with unionizing campaigns, and 2 Amazon tech workers posted and emailed about support for the warehouse workers and their campaigns to get safer working conditions related to COVID-19. So these 2 tech workers who worked in Seattle were not direct co-workers of these warehouse workers. forwarded a petition that the warehouse workers had put together asking the public to sign to advocate for Amazon to give them safer working conditions related to COVID-19. They forwarded that petition to coworkers on their various tech listservs. They tweeted about it on their personal Twitter accounts, both posting statements in support of the workers, statements critical of the conditions at the warehouses, and posting fundraisers for warehouse workers who had been affected by COVID-19. And perhaps unsurprisingly, shortly after, they were terminated by Amazon. And so this is a case where that ended up in the National Labor Relations Board, and in the past year, the National Labor Relations Board General Counsel's Office Division of Advice issued a memorandum about this. So we'll talk about it and get back to it a little bit later. But I thought to set the stage for this was a good example to start off with in our minds. So I wanted to frame the talk today to both explain what I'm going to be talking about and what I'm not going to be talking about. So I'm going to be talking about generally, when is a social media post protected by the National Labor Relations Act? So there are a number of other laws that can concern or relate to social media posting, and those are all very interesting and important, but I will not be discussing them today. So that just the focus is on the National Labor Relations Act. The National Labor Relations Act, as many of you probably know, but just in case, it is a federal law that governs the private sector workforce. So not the public sector, although NLRB precedent is often persuasive for public sector labor boards, meaning that the public sector labor boards will look to and sometimes follow the case law. But generally it covers private sector workers with some exceptions. It doesn't cover independent contractors, doesn't cover domestic workers, doesn't cover farm workers. There's various exceptions like that. But so generally I'll be talking about the NLRA. And I'll be talking about what do these protections mean for you as a worker, whether you're unionized or not, or you're someone who's trying to organize new unions, new workers, and how do these protections get enforced? So something that I wanted to also discuss up front is the main legal avenues to fight discipline and what I will and will not be talking about. So if you are part of a union and a union that has a collective bargaining agreement, you're probably covered by a just cause provision, or a provision in your collective bargaining agreement that says that your employer can only discipline or discharge you for good cause. And that is the main avenue, and usually the quickest and best avenue to contest your discipline. And then if you have any specific language in your contract about either off-duty conduct or social media, that'll be something that you may want to incorporate into your argument should you go to arbitration. However, I'm not going to be talking about how arbitrators analyze these issues about social media and whether there's just cause for discipline based on social media postings. That's its own sort of topic that could take up a whole nother presentation. But the other avenue is, an unfair labor practice charge filed with the National Labor Relations Board, which I am going to talk about. And unfair labor practice charges can be helpful both for non-unionized workers and unionized workers, because the NLRA does cover workers who aren't in a union, as well as workers who are. And so ULPs, though, can also be helpful for workers who are in a union, because as I'll talk about in a bit, when you file what's called an unfair labor practice charge with the NLRB to try to enforce your rights. So let's say you were terminated or got a suspension for posting something on social media and you think it's protected by the act, you can at some point request that the charge be deferred to arbitration. And there's a sort of a lot of nuances about that, but generally what that means is that you are then asking the board to say, hey, Mr. or Mrs. Arbitrator, in addition to analyzing whether this employee was discharged for just cause, I also want you to analyze whether you think this employee was discharged in violation of the National Labor Relations Act. So that's a helpful tool, because normally if you go to arbitration, the arbitrator just looks at the contract, everything within the four corners of the contract, and doesn't interpret outside law. And while some arbitrators will incorporate into their just cause analysis whether the activity was something that's sort of generic union activity or protected concerted activity. Some won't, and it's helpful then to have that way to give them a hook into analyzing the National Labor Relations Act. So that's something to think about, even if you are already part of a unionized workforce that has a collective bargaining agreement with a just cause provision, and why it can still be helpful to know and use this analysis about protected activity. So quick overview about the NLRB. A lot of you probably are familiar with this if you're alumni of the program, but the NLRB is the federal administrative agency that enforces the National Labor Relations Act. There are two overarching branches. There's the General Counsel's Office and the board. The board is a 5-member board in Washington, D.C. They are appointed by the president and confirmed by the Senate. They have 5-year terms and they're staggered so that one member's term expires each year. It's generally 3-2, so 3 Democrats, 2 Republicans. If it's a Democratic administration, 3 Republicans, 2 Democrats. If it's a Republican administration, and that generally lines up with the Democratic appointees being more pro-worker and the Republican appointees being more pro-employer. And so the General Counsel's Office is the other half, and the General Counsel is sort of the prosecutor for the National Labor Relations Act. So you can't just go to court like you might with other laws to try to enforce the National Labor Relations Act. You have to go through the NLRB, you have to go to the regional offices and file an unfair labor practice charge. And then the region, which is overseen by the General Counsel's Office, will decide, do we think there's merit here? Do we think this is something worth pursuing? And if so, they'll issue what's called a complaint, which is sort of formalizing the charge and can lead to a hearing in front of an administrative law judge at the board. But if the region or the board say, hey, we don't think you have a charge here, you can't just go to court yourself. It's all through the General Counsel's Office. And so something I wanted to lay out in advance of the rest of the presentation is also that the General Counsel determines priorities for what kinds of cases to pursue. And that is really important to think about and note here in this time where we're sort of in flux in labor law, because the Trump board issued a number of really terrible decisions. Joe Biden didn't get to nominate enough folks to get a majority on the board until last summer. And because the then full Biden board has only been in office for a short period of time, they haven't yet reversed a lot of the bad Trump era precedent. So a lot of Trump era precedent that will probably change soon is technically still the law, but you can go to the NLRB's website, look at the General Counsel's memos and Division of Advice memos, which is a part of the General Counsel's Office, and get an idea of what does the current General Counsel think the state of the law is now. What do they advocate that it should be and should be changed to? And so that'll give you an idea of likely what the law will look like in the next few years. Okay, so talking about getting into the actual protections here. So what does the NLRA protect? And so the main things I'm going to focus on today are the NLRA's protections for covered workers' rights to engage in union activity, and then also protected concerted activity for mutual aid or protection. So that first category, union activity, is pretty normally easy to categorize or spot. So it could be filing a grievance, representing a coworker at a grievance hearing, discussing issues with management at a labor management meeting, advocating for coworkers to join the union, that sort of thing. But it's this latter activity that is a little bit more nebulous and has a lot of different nooks and crannies where it can or cannot be defined. So social media postings can fall under the protections of the National Labor Relations Act if they constitute union activity or protected concerted activity for mutual aid or protection. So we're going to talk about sort of what that looks like and what that looks like in the social media context. Here's the text of Section 7 of the NLRA, which enshrines this right of workers to engage in other concerted activities for the purpose of collective bargaining or other mutual aid or protection, which is a mouthful and is a stupid term of art. But so just breaking it down a little bit, concerted. So what does concerted activity mean? And then what does that look like in the social media context? So generically, and as you probably know, concerted normally means, with or on the authority of other employees. So the typical example is, a worker talks to their coworkers and they say, hey, I really don't like this new policy about overtime. And then they agree as a group to go talk to the boss about it. So that's sort of the normal, easiest example. But there are a number of other ways that activity could be concerted. So activity can also be concerted if it's, even if it's just preliminary discussions that are engaged in to initiate, induce, or prepare for group action. So, and that goal doesn't need to be explicit. So you don't need to, in order for something to be protected, you don't have to explicitly say with your coworkers, hey, what are we gonna do about this? Are we gonna do a petition? Are we gonna walk out? It can just be discussions about an issue in the workplace, like, oh, I really don't like this new pay policy. I really don't like this new scheduling policy. And even if your discussions have not yet gotten to the point of planning any group action explicitly, it can still be considered concerted activity under the Act. It could also be the logical outgrowth of earlier collective discussions. And so there's an example that I'll talk about in just a bit where that's the case. So if you've been talking to coworkers before about the certain issue, and then you as an individual raise that issue, to the public, to your bosses, to someone else like that, that can still be concerted, even if it was just you yourself speaking on that. It could also be, a single employee reaching out to other workers for support for an action that will only help that individual employee in the short term, but might help others in the long term. And that's called sort of the solidarity principle. So there's an example of a board case where an employee had been the victim of some sexual harassment, and she filed an internal complaint. And as part of filing that internal complaint, she asked some coworkers to, sign a statement or a picture related to the alleged sexual harassment. And so even though she really was only advocating for herself technically in that moment and to vindicate her rights not to be sexually harassed, because she was reaching out to coworkers and asking for support for that action, that can be considered concerted as well. And also some types of conduct and speech can be inherently concerted. So if you're talking about wages or job security, those things can be concerted even if you're not necessarily engaging with other workers on that issue. Yeah, so an example of when activity is concerted in the social media context. So there was a 2018 decision by the board called Northwest Rural Electric Cooperative. And in that case, an electrical worker posted a comment on a popular Facebook page dedicated to safety issues for linemen, complaining about safety practices of his employer without naming the employer specifically, and the industry in general. And his employer ended up seeing the comment and firing him for that. The board ultimately found that this comment was concerted activity because some of his coworkers liked the Facebook page and therefore had access to his comment. The employee had previously brought up and discussed the same concerns with coworkers and management, so this was sort of a continuation of those earlier collective discussions. And his comment constituted an employee sort of enlisting the support of coworkers and other employees in the industry for their mutual aid and support for his concerns about safety. So there's a number of ways in which it was concerted. And something that often comes up, but is not necessarily required to be concerted, is, if coworkers or other employees like your post, comment on your post, that sort of thing. That is an easy way to show, look, this is concerted, but that's not the only way. So even if no one responds to your tweet or your Facebook post and you get fired for it or disciplined for it, it could still be considered protected under the Act, could still be considered concerted activity if it's concerted in one of these other ways. And also, it's something that just to clarify, it doesn't also have to be, the concerted activity does not have to be on like the official authorization of other workers. You don't have to have talked to other workers and they said, I elect you to go to the boss to speak about this, or I really elect you to tweet about this. It can be sort of implicit authorization, where you've spoken to coworkers about an issue and they indicated they want you to speak out on the issue, or even short of that. Part of the reasoning, especially about the protecting preliminary discussions, even if you haven't yet engaged in explicitly planning for group activity, is that those preliminary discussions are, the necessary preludes to that group action. So if the board sort of reasons that if those types of discussions weren't protected as concerted activity, that would be sort of nonsensical, because you need to be able to engage in those discussions with other workers about workplace issues before you can even get to the point of planning any group activity. In terms of also what's considered inherently concerted, the case law has mostly focused on discussions about wages, job security, and even scheduling. The theory is these subjects are such vital terms and conditions of employment that these discussions and these discussions are often preliminary to organizing or other action, that they should just be concerted, even if you didn't really talk to other coworkers about it. In a recent Division of Advice memorandum, the Office of the General Counsel directed a region to argue to expand that scope of topics that is considered inherently concerted. So there hasn't yet been a board ruling on this issue, but there likely will be in the near future. And the memo urged the region to argue that discussions about the quality of supervision should be also considered to be inherently concerted, because the quality of your supervision is tied to so many issues at work that they felt that should be added to that category. So that's something to look out for too. So if someone ends up posting about, their frustrations with their boss, the quality of the boss, not providing good support, scheduling them at weird times, that sort of thing, that can also be inherently concerted. Another example of when social media activity that might not appear to be concerted ended up being found to be concerted is a case from 2019 called Desert Cab. And in that case, there was a chauffeur who was terminated for Facebook posts on his private Facebook page complaining about his employer's new policy that prohibited drivers from picking up other more lucrative customers from hotels while waiting for customers of this one client, a helicopter tourism company, who did not tip as well. So normally, instead of waiting for 3 hours and not getting any additional pay, he could have gone to a fancy hotel in the area, picked up some clients there, would have gotten paid more, would have gotten tipped better for that. But instead, because of his employer's new policy, he was making less money and had to sit and idle while he waited for these customers at this helicopter tourism company. So he had spoken to a bunch of coworkers about this. They were all really frustrated because it meant that they would make a lot less money on the days they were assigned to drive for this helicopter tourism company. Excuse me. He had also texted management about the issue. Management didn't respond. And so in frustration, he ended up posting on his private personal Facebook page a photo of 7 or 8 limos just idling in the parking lot at the helicopter tourism company, and said, hanging at the morgue, we are sent to sit around for 3 hours for no reason. And some coworkers did comment and like on that. And again, that doesn't sort of explicitly reference this new policy, but it does clearly refer to this change in policy when you look at it in the context. He ended up also making another post later, which was a photo of the entrance of this helicopter company client, and said, when it's a truly crappy day at work and there's nothing you can do about it. And 6 of his coworkers liked and commented, I know the feeling, that sort of thing. So when he was terminated, he ended up filing a charge with the National Labor Relations Board. A complaint was issued and it went to hearing in front of an administrative law judge. And the administrative law judge found that this activity was concerted for a few reasons. One, coworkers did like and comment on it, but also this was a logical outgrowth of earlier collective discussions that he and his coworkers had about this change in policy. He had even already reached out to management about it, but they just hadn't done anything about it or responded. They also found it was inherently concerted activity because it had to do with his wages. And something interesting here is that the text of the posts themselves don't say, I'm getting paid less today because I was assigned to this helicopter tourism company. It's not explicit, but the board still found that these posts dealt with wages and terms and conditions of employment because of the context in which they were posted. So even sometimes if you or a coworker or someone you're organizing ends up getting disciplined or discharged for a social media post that you may initially think is not related to terms and conditions of employment or may not be concerted, you always want to find out the larger context and the background facts because you may be surprised. And finally, just a clarification or just another point to make is that the board says that individual griping is not concerted. So for example, there was a division of advice memo in the past few years about a Trader Joe's employee who posted on Instagram and I think maybe Facebook complaining about customers coming to the store during the pandemic just to get out of the house and taking their time shopping. And no one commented or liked this, and the division of advice said this isn't concerted. This wasn't the outgrowth of earlier collective discussions. This isn't inherently concerted because really it's just criticizing the customers and doesn't have to do with wages, scheduling, anything like that. And it was not done with or on the authority of other employees. So you always want to try to differentiate between individual griping and concerted activity. The line isn't always clear, both because the case law sometimes isn't clear, and also because the makeup of the board changes and the general counsel changes. So now activity that the Trump board may not have found concerted, the new board may. So that's something to keep in mind when you're thinking about filing charges or making arguments to your employer about what's protected or what's not. So the second part of this is it has to be concerted activity for mutual aid or protection. And that generally means, dealing with wages, hours, working conditions, or other terms and conditions of employment. And something also to clarify is that this doesn't have to be for mutual aid or protection of immediate coworkers. It could be for mutual aid or protection of employees generally at other workplaces. So it could be warehouse workers that aren't your immediate coworkers. It could be workers at another employer. And so that's something that's important to keep in mind. So even if a social media post doesn't deal specifically with your own workplace, it still could be protected under the Act. And the general concept of mutual aid or protection focuses on the goal of the concerted activity. So whether the employee or employees involved are seeking to improve terms and conditions of employment or otherwise improve their lot as employees. Something important also to point out is that employee motive is not necessarily relevant to whether the activity is engaged in for mutual aid or protection. So even if an employee didn't explicitly think in their head, like, I want to improve my working conditions, that doesn't matter. It could still be considered activity for mutual aid or protection. The analysis just focuses on whether there is a link between the employee activity and matters concerning the workplace or employees' interest as employees. And so employees' activity also can be protected as mutual activity for mutual aid or protection when the employees are seeking to improve their lot as employees through channels outside the immediate employer-employee relationship. So that means sort of what's generally thought of as like more political activity. So advocating advocating to city council, to a state representative, to Congress, something like that, as long as it has a connection then to the employee-employer relationship. So in the test generally, is there a direct nexus between the employment-related concerns and then the specific issues that are the subject of the advocacy? So an example of this is in 2008, the NLRB General Counsel issued a memo finding that workers who walked out of work for a day, a Day Without Immigrants protest, some of you might remember that, that they did engage in concerted activity for mutual aid or protection, but that the activity ended up losing its protection because of the manner in which they conducted their activity. But the general counsel said, yes, this is protected because, this is for mutual aid or protection because there is a direct nexus between the workers' protest of some legislation that would require prospective employees to get a number of clearances before they could work in the US, and would mandate that prospective employers verify each employee's paperwork or get penalties, because immigrant and non-immigrant employees could reasonably have believed that the bill would impact their interests as employees. So therefore, there was a nexus between these protests, which might, some folks might say that's not really related to your employment, but the general counsel took like a broader view of what that means to be connected to your employment. Ultimately, the general counsel's memo found that it lost its protection because they withheld their services not as an economic weapon, but to obtain a goal over which the employer had no control. So that's sort of a separate issue we'll talk about later about losing protection. But in terms of talking about whether the subject of your statement, your advocacy, your social media post, whether it constitutes for mutual aid or protection, again, doesn't have to be specific to you talking to your employer or advocating for change directly in your workplace, could be something outside of those avenues as well. Okay, and then this is where things get a little bit dicier, just in terms of the case law and in terms of analyzing situations. So one thing to note is that even if you or a coworker or another employee engage in concerted activity for mutual aid or protection that normally would be protected under the Act, your speech or conduct can lose the protection of the Act in certain circumstances. And generally, and especially in the past, the protected conduct must be really egregious or offensive to lose protection. So I'm going to talk a little bit about the recent history of the case law, because the case law has sort of changed on this and likely will change again in the near future. So there are different tests for evaluating whether activity loses protection. So the one that was the mainstay for many years recently was what's called the Atlantic Steel test, and that's just the name of the case where it came out of. And this test was mainly used for in-person on the worksite confrontation with management. For example, like if someone is meeting with management about their pay or something like that, and ends up using swear words, saying like "you mother effer," or ends up yelling at the boss or supervisor while they're engaging in this otherwise protected activity, or even sometimes making threats of violence or implicit threats of violence or using racial slurs, the board often found that didn't lose protection. There was sort of this default assumption that if you were engaging in protected activity, it was very hard to lose protection under the Act. That's not to say it never happened, but it was very hard. And there was 4 different factors that the board would evaluate and weigh to determine whether your conduct or speech lost protection of the Act under this Atlantic Steel test. Basically, it was these factors were used to determine when the conduct was so opprobrious as to lose protection. And so they would look at one, the place of the discussion. So whether it was in private, was it on the shop floor? Was it during labor management meeting? Was it in front of customers? It would look at 2, the subject matter of the discussion. So what were you talking about? Was it just like, oh, I don't like the food that they're serving here at work? Or was it something more directly related to, scheduling, pay, termination, policies, that sort of thing? 3 is the nature of the outburst. So, how egregious was it? How, loud or offensive was it? And also 4, whether the outburst was provoked by the employer's unfair labor practices. So that can come up in the context of, if the employer is, for instance, like interrogating employees in a way that is unlawful under the Act, and that is what brought about the outburst, then that could weigh in favor of the activity not losing protection. And sort of the reasoning behind this was that the board said, emotions run high during labor disputes, and therefore we're going to give some wider latitude to speech and conduct done that constitutes Section 7 activity. You know, rude and emotional outbursts are okay, even if they're rude and loud, but they only would lose the Act's protection if flagrant or egregious. And again, the latitude in the context of a labor dispute means labor dispute defined broadly. So not just contract negotiations or strike, but just generally disputes about labor conditions. So it could even be non-union workers discussing issues about their paychecks or something like that. And you know, sometimes if the activity was, or the outburst was in front of customers or something like that, where it could affect the employer's business, that might weigh against protection. And initially in the early 2010s, the board did apply that test to social media posts. But eventually they sort of said, okay, this is sort of like sticking a round peg in a square hole, because this test was made for on-site workplace confrontations with management, and social media posts are often sort of outside of the work context, often done on your own time, even sometimes done in private Facebook pages, or you know, it could be an appeal to a third party. So let's use instead this totality of the circumstances test. And it used some of the same factors. And this was from a case called Pier 60. And the factors included, you know, evidence of the employer's anti-union hostility. So if it was pretty clear that the employer was hostile to unions or worker activism in general, that could weigh in favor of the social media post keeping protection under the Act. Whether the employer provoked the conduct, again, that would also weigh the same way. Whether the conduct was impulsive or deliberate. So if it's impulsive, that sort of weighs more in favor of protection, because you know, it shows that it was in the heat of the moment, really, you know, worked up about labor conditions, and wasn't sort of a forethought, malicious attack on the employer. Also, they would look at the location of the social media post. Was it a private page? Was it a public page? Did it get disseminated across the internet, even if it was on a private page? The subject matter of the post, so similar to before, the Atlantic Steel test, does it have to do with wages, hours, working conditions, or does it just have to do with some griping about the customers or something like that? And griping about the customers in a way that doesn't impact your terms and conditions of employment. The nature of the post, whether the employer has considered similar language to be offensive and has disciplined other employees for similar language. So if you posted about like, my mother effing boss is riding me hard today, and you know, just keeps giving me infractions for small things. If normally the employer doesn't discipline people for using talk like that in the workplace, and it's actually pretty common, then you know, that leans towards that post maintaining protection under the Act. They also looked at whether the employer maintained a specific rule prohibiting the language at issue. And as I mentioned, whether discipline was imposed for similar violations, or whether this was disproportionate. And the board never really clarified exactly how they weighed all these different factors, so it was very mushy. And then, I'll talk about it in a second. There was then a 2020 board case by the Trump board that sort of flipped the board on all of this and said, we don't like this Atlantic Steel test. Employers generally hate it, and said, you know, it's so mushy. We don't, you know, it's never clear how you weigh the factors. You know, it's crazy that if we try to fire someone for, you know, even using a racial slur, it could turn out that we have to put them back to work if they use the racial slur or use the profanity in the context of protected activity under the Act. And so this General Motors test, they created a new test that basically says no more Atlantic Steel for abusive speech and conduct, profane ad hominem attacks or racial slurs. You know, we're going to separate those out from the protected activity. Whereas before, the board looked at them as sort of one and two sides of the same coin, and said like, well, if you're disciplining them for that speech or that activity, and that speech or activity was protected under the Act, even if it also had these other like rougher elements, you can't really separate those out, and we're going to, you know, default to it being protected. It's only if it's super egregious that it loses protection. The board said no more of that. We think we can separate out this abusive conduct and the protected conduct, And so basically we're gonna use a new test, an old test in this new context. And basically they said you have to use this right line test, which is just the name of another case. And it means that the general counsel, if the general counsel wants to show that an employer violated the act by disciplining or discharging someone for Section 7 activity, they first have to show that the employee actually engaged in the activity, the employer knew of the activity, and the employer had animus against the activity, which had to be proven with evidence sufficient to show a causal relationship between the discipline and the Section 7 activity. And then the burden shifts to the employer to show that it would have taken the same action, even if there would have been no protected activity involved. And this is sort of the main context then where they change things to say, whereas before the board said, that's not a legitimate good enough reason to say that you're worried about liability under federal discrimination laws. And so that's why you discipline this employee who used a racial slur during the protected activity. Now the board will say, yes, we think that's a legitimate reason. If you were trying to protect your workers and your bottom line, your liability by disciplining someone for harassment or racial slurs or using profane language, profane name calling, we think that's a legitimate reason to fire someone. We don't think that you're actually firing them for that protected activity, and therefore, that activity will lose protection, no longer going to be protected under the act. That changes things a lot because, for instance, the social media post from that Pier 60 case would probably lose protection. And in that case, there had been a catering employee was fired for posting on Facebook 2 days before a union election about a manager and his family in response to a manager treating him in a way that he felt was disrespectful on the job. He had posted, "Bob is such a nasty mother effer," but I swear in real life, but I don't know here, I'm just gonna say mother effer. Nasty mother effer, don't know how to talk to people, F his mother and his entire effing family, what a loser, vote yes for the union. And there, in that case, the board found that the post was protected concerted activity for mutual aid or protection and union activity, and did not lose protection under the act for being opprobrious. They said, it was provoked by ULPs. The employer had been committing a bunch of unfair labor practices throughout the union campaign. It was provoked by the employer because the manager had been kind of a dick to this employee. It was done on a break. It was an impulsive post by this employee. And similar language was used at the workplace, like swears, name calling, that sort of thing. And folks didn't really get disciplined for it. But now, analyzed under this new test, it's likely that the board would say, actually, that's not protected. And you, employer, had a legitimate reason to fire that guy. He called you a nasty mother effer. Like, that's just not okay. We agree. That's legitimate to fire them. And so, in the General Motors case, the member Lauren McFerrin, who was the only Democratic member at the time, issued a fiery dissent, and that's probably what now is going to end up being the law very soon. So if you're curious about how it'll switch back, you can read the dissent in that case. And in a recent Division of Advice memo from the General Counsel's office, the Division of Advice argued that General Motors, this new case, should only be applied narrowly, if at all. It should be limited to cases involving profane language, threats of violence, and racist actions, and that it should not be used for all forms of alleged misconduct, and also that General Motors probably should be overturned. So in the near future, probably will be overturned. But something also to note is that, so General Motors, even though there was no social media posting involved in the case, the Trump board really likes to just sweep really far and make as many changes as they could at the same time, because they said, like, F it, we just want to change the law. So in General Motors, they said this test also is going to be used for social media postings. So no more of this mushy Pier 60 thing. Even for social media postings, you now have to use the right line test. And when the employer has these legitimate defenses, the action is probably not protected unless there are some other circumstances that show that really it wasn't for the conduct, it was for some other reason. So right now, technically, if you or a coworker or a bargaining unit member is disciplined or discharged for a social media post, General Motors applies, meaning, if there was even implicit threat of violence or, profanity, particularly directed at management, or, it's technically, the board would probably, if the board applied its pre-existing law, it would say that's not protected. But, know that that law is probably going to change soon. And the General Counsel has also issued a memo with what are called mandatory submissions to advice, meaning that, hey, region, anytime you get a charge on this topic, you have to submit it to the General Counsel's office in DC so that we can advise you on how we think you should move forward with this case, what you should make arguments about. And one of the mandatory submissions to advice right now is any charge involving General Motors activity. So if you go and file a charge right now for something, for a social media post that's otherwise protected, considered activity for mutual aid or protection, or union activity, but it might lose protection under this General Motors test, still go ahead and file it, still go ahead and make that argument, because that law is probably changing, and you could be part of the catalyst that changes that law. So so it's possible then that the Biden board would go back to that totality of the circumstances test in social media cases, which is much mushier and defaults more to protection for the worker's activity. Another way that activity can lose protection of the act is for disloyalty. And it comes from this Jefferson Standard case, 1953 Supreme Court case. It's mainly used for comments directed at third parties like the public, customers of the employer, Congress, that sort of thing. And basically, the court in that case had ruled that employee public attacks on the quality of the employer's products, services, or operations are protected by the act when they are, one, made in furtherance of a union's position in a labor dispute, and two, not extremely disloyal, reckless, or maliciously untrue. So that's a bunch of mouthful BS, and so it's sort of, what does that mean? So there are a bunch of cases interpreting what that means, and some of them are sort of all over the place, and it can go back and forth depending on the makeup of the board. But to give you the context for that initial case, those were technicians at a Charlotte, North Carolina broadcasting company that were picketing their employer during negotiations for a new collective bargaining contract. And they picketed and distributed flyers criticizing the employer with the headline, "Is Charlotte a second-class city?" saying Charlotte deserves TV coverage of local sports and other events, and the employer is refusing to invest in the equipment to provide it. But the flyer did not mention the union or the labor dispute, and the employer ended up firing some of the picketers. And so the Supreme Court upheld the firings, finding that the employees' distribution of the flyer lost their protections under the act, because the attack was on the employer, aimed at harming the company's financial interests, attacking the nature of their products and services, and unrelated to the labor dispute. And so there's a few questions you want to ask yourself when you're in a situation where a bargaining unit member comes to you, or a coworker, or you yourself have a situation where you have a social media post and that otherwise might be protected, but you worry that they're going to have a Jefferson Standard issue because it disparages the employer in some way, disparages the employer's product, services, anything like that. So first you want to ask, is this employee communication to a third party a disparaging attack on the quality of the employer's product or policies? So, in that example, from Jefferson Standard, the employees were attacking the quality of the programming. They weren't attacking something more directly related to their working conditions. Where on the other hand, in a case from the last decade, the NLRB found that a car dealership employee criticizing the low quality of his employer's snacks at a sales event online was not disparaging the quality of the employer's product, but instead it was really criticizing the employer's sales methods, which relate directly to the employee's working conditions, because the workers were paid on commission, and arguably they'll make more money if the snacks are fancy enough to attract wealthy clients. So even though, initially you might look at that case and say, he's just talking about the crap type of food that the employer puts out at these events, that seems like it's unrelated to working conditions. It seems like it's just a disparaging tack on the employer. When you look at it in the context of the commissions and the snacks attracting wealthier customers who would then buy more from the clients, or excuse me, from the workers, and they would get higher wages, that sort of changes the context. You also want to ask if the communication was made in a manner reasonably calculated to harm the employer's reputation and motive, which is similar sort of thing. So for example, if a communication was arguably made for purposes of working conditions like increasing staffing, then it wasn't made just solely in order to harm the employer's bottom line and doesn't lose protection. So again, the important part is the connection, either implicit or explicit, to an ongoing labor dispute. And again, labor dispute doesn't have to mean union, doesn't have to mean union strike, union picketing. It could mean non-union employees having an issue at their workplace. Sometimes they'll also analyze, you want to ask whether the communication was made at a critical time for the business. So sometimes if it's made when there was just a merger or a new opening of a store or something like that, that can lean towards the conduct losing, or the conduct or comments losing protection. And again, another important thing is, did the employee identify that the comment was related to an ongoing labor dispute, broadly defined? And so it's always better, it'll be easier to argue that you didn't lose protection if there's an explicit connection in the comment or post to an ongoing labor dispute. So for example, a nurse made comments to a newspaper about staffing levels at her hospital and its effect on patients and nurses' working conditions, and publicly identified that she was a steward for a bargaining unit that was in negotiations about staffing levels. And the board said, okay, that's protected. You didn't lose protection because even though you're criticizing the employer about its services in terms of how they treat patients, you connected it to the staffing and you connected it to that impact of your daily working conditions. And that's clear to any third party reading this newspaper comment. And another thing to consider is, did the employee make the communication with malicious intent? Was it just to hurt the business, or was it related to their their conditions? And did the employee make the comment knowing it was false, or with reckless disregard for whether it was false? So, if an employee ends up posting something about, they think that they heard that the employer is going to make a certain change in policies at work, and it turns out that that's not true. It's okay if it turns out that's not true. That doesn't mean you lost protection under the act. But as long as the employee genuinely and reasonably believed the comments, believed that what they were saying was true at the time and later found out it was wrong. But if the employee knows, or probably should know, that what they're saying is wrong, it can likely lose protection of the act. Sort of takeaways about when either training members, stewards, or just for yourself on what to post on social media without losing protection under the act. You want to emphasize that for now, you want to keep it clean if you can. Obviously, the law is probably changing on that soon, but generally under the existing law, profanity, profane attacks, personal attacks on management will probably lose protection until that case is overturned. And when posting about the employer or your working conditions in connection to something disparaging about the employer or its products or services, you want to make sure that there's an explicit connection to an ongoing labor dispute or just your terms and conditions of employment as an employee. Also want to make sure to tell folks, if you're posting something that may be false, they may want to double check on it before they post. Again, if it turns out they genuinely believed it to be true at the time, it doesn't mean it'll lose protection, but those are just some tips. And again, that doesn't mean that just because any of these factors exist, a social media posting will lose protection. It's all about, the probabilities and, gaming out how you think the board may or may not rule. And ultimately it is a very fact-specific inquiry. And so here's just an example about a ULP particularly related to advocating outside of the normal channels of employer-employee. In a 1991 case at Motorola, the employer prohibited distribution of literature with suggested messages to city council supporting a proposal to ban mandatory drug testing. And the board found that that literature was directly related to working conditions. So the ban on distribution anytime and anywhere on the employer's property violated the act. So even though it wasn't a flyer saying, hey, please call the employer and let them know that we want you to change this drug testing policy, even though it was something that was directed to an outside party, like having people call city council, because that was related to whether they would have to be have mandatory drug testing at work, that still is protected concerted activity for mutual aid or protection. So even if folks are posting, tweeting about, ask folks to call city council and tell them to vote for the Fair Workweek Act or something like that, that still could be protected concerted activity for mutual aid or protection. Doesn't matter that it's not explicitly about the direct relationship between employee and employer. Also just check the time. Okay, I'll rush a little bit because I want to get to time to hypotheticals. But in terms of, how it actually sort of plays out, when you go to the region and you want to file a charge, what are you alleging? In terms of, like, let's say you or your coworker got fired or disciplined for posting something on social media that you think may be protected by the act. Basically, you're going in and saying, hey, the employer violated Section 8A1 of the National Labor Relations Act, or 8A3, which we'll talk about in a second, when the employer disciplined me or this employee for engaging in activity protected by Section 7. And Section 8 of the Act is the one that goes through and specifically says, like, here's how an employer or a union could violate the Act. And so 8A1 is the provision that covers both unionized workers and non-unionized workers, and covers activity that is protected but unrelated to unionization. So it could be just talking about tips, wages, safety conditions, that sort of thing. And so when you go and file that charge, the board is going to say to itself, okay, if we go to a hearing on this, we're going to have to prove certain things. And can we prove those certain things? So first, the general counsel will have to show that the activity was concerted. So I talked about, and hopefully we'll talk with you guys about what concerted activity looks like. They'll also have to show that the employer knew about the protected concerted activity. So if it turns out the employer didn't actually know about it, then obviously they couldn't have fired you for that activity. They'll have to show that the activity did not lose its protection through one of those ways we talked about in terms of profanity, racial slurs, disparaging of the employer unrelated to working conditions, and has to show that the discipline was motivated by the employee's protected concerted activity. And there are a number of ways that the general counsel can meet this burden. It doesn't have to be a situation where the employer explicitly says, I am firing you because you engaged in protected concerted activity for mutual aid or protection. The general counsel can rely on sort of circumstantial evidence of anti-union animus. So if there was suspect timing around the discharge, if it came really close to the protected activity. So here it'd be like the social media posting. Or if the employer normally didn't discipline other employees for that same sort of thing that they're claiming they're disciplining you for. Or if the employer had made other comments in general about anti-worker, anti-union animus, that can be then sort of attributed or built as part of the context of the case and the employer's motivation. The thing also, another thing to note here is that sometimes the test will be a little bit different about what the general counsel has to establish depending on the specific facts of the case, but this is sort of the generically what they have to prove. And then Section 8A3 specifically relates to union activity. So if you or a coworker or someone else engaged in, a a social media posting about vote for the union, or, you know, come to this union meeting, that sort of thing. 8A3 is the section of the act that you will be alleging that the employer violated. And it's a similar test to 8A1. You know, the general counsel will have to establish activity, well, here, that it was union activity, the employer knew about it, the employer was motivated by anti-union animus, and that the anti-union animus caused the discipline or discharge. And then again, the burden will shift to the employer to rebut the initial case, showing that, no, that's not why I discharged them. It was for this other reason. Or, you know, even if they hadn't engaged in that action, that is this union action, I would have fired them anyway. They had like 11 patient complaints against them or something like that. So that's sort of the analysis that the board will be thinking about when they're deciding whether or not to issue a complaint. And something to also point out here is that as a lot of folks who have dealt with NLRB before know, all of this unfortunately takes a lot of time. The filing of the charge, you know, going through, waiting for the board to decide whether they're going to issue a complaint, going to a hearing, then you get the decision, then that can be appealed to the 5-member board, and then that can be appealed to the appellate court. So, you know, relying on the act all the time, or relying on the NLRB to enforce the act, isn't necessarily going to get you what you want in every scenario. You can use it sort of strategically if you think it's gonna help you in the short term with a campaign or something like that, or you can use it to, you know, help you or a worker, but know that the actual end result of when you might get back pay or something like that will be a few years down the line. But there are also ways, points along that long trajectory where you could get a resolution. So before the region issues a complaint, they'll often tell the employer, hey, we decided we're going to issue a complaint. Do you want to try to settle this? And so at that point, you know, depending on how open the employer is to settlement, they'll sit down and talk with the NLRB and the charging party about what a settlement could look like. So that example I gave at the beginning about the Amazon tech workers, after the Division of Advice issued a memo saying, yeah, we think that this is protected. We think that the General Motors case should be overturned, and we don't think it would even apply here anyway. We don't think this was disparaging of the employer in a way that lost protection of the act. They said, hey, region, issue this complaint. And then Amazon ended up settling. They, instead of saying, you know, instead of risking the time and money to defend it, Amazon just said, great, we're going to settle with you. And so they end up paying back pay to the workers and having to send out a notice to employees saying like, hey, we're not going to violate the act again. And that's only so helpful. Again, the remedies available under the National Labor Relations Act are pretty toothless right now. And there is legislation to change that. There's the PRO Act, which probably, unfortunately, isn't going to pass in the near future, which would change the penalties for violating the act. There was even part of the Build Back Better Act that would add monetary penalties so that if an employer violated the act, you know, they would have to pay a one-time fee of like $50,000 or $100,000, unrelated to any back pay liability. But right now, that's just not the case. So again, you know, you use the board for what it's worth and the board process for how it can be helpful to you, but also know that just filing a charge and getting it deferred to arbitration if you can be helpful, so that you have that extra ammunition, that extra argument to make in arbitration about why someone shouldn't have been disciplined or discharged. Okay, 11:05. Yes, I know we're getting close to the end. So I just wanted to give like one example, and then, you know, if folks, I know it's like early on a Saturday morning, most of us are like, I just want to go back to sleep. So if you don't, no one wants to pipe up, totally cool. But if anyone wants to, you know, after I go through the facts, say like, hey, here's how I think that might be analyzed. Pop off of, you know, raise your hand on Zoom and get off of mute and, you know, go from there. Okay, so this is an example from a recent advice memorandum called Johns Creek Surgery. So this was a situation where their employees worked at a surgery clinic. A bunch of employees were discussing with each other issues with their supervisors, and like one supervisor in particular who they felt was a bad supervisor, and was sort of, you know, an ass, abusive-ish, and also just like not supportive, not good with scheduling, that sort of thing. And so the charging party complained about, workload becoming unmanageable, partially due to the supervisor's management. And the charging party even spoke with a coworker who said, yeah, I'm resigning mostly because of the supervisors. I think they're crap, particularly this one supervisor. Get to the next slide. Here we go. Then the charging party ended up posting to his personal Facebook page where he was friends with some coworkers and said, just in case someone needed to know, followed by a shrugging emoji, and then a meme stating a bad manager can take a good staff and destroy it, causing the best employees to flee and the remainder to lose all motivation. And then below that wrote, employees don't leave companies, they leave managers. The post was liked by at least 90 people. One coworker commented, yes, freaking yes. And another coworker, the coworker who was leaving, commented with an emoji showing a face with no mouth. Then somehow the supervisor saw it, took a screenshot of it and texted it to that coworker one saying, just a heads up. And that coworker texted the charging party, said, the supervisor saw it. I'm worried about what's going to happen. They also talked about the fact that, yeah, the supervisor sucking is what it sort of led to our coworker leaving. The next day, the supervisor confronted the coworker about the post. That night, the next day, the employer terminated the charging party allegedly because there were 11. He had 11 patient complaints from the prior month, which the employer had not brought up previously. So in this situation, if it's you or a coworker, another bargaining unit member who says, okay, I just got fired. It was right after I made this post about my supervisor and the quality of my supervision. They're claiming they fired me for these patient complaints from last month, which I never even heard about. What should I do? Should I go to the labor board? If I file a grievance, what argument can I make there about this as it relates to activity protection under the Act? Does anyone have any thoughts about how you would first start to think about this or analyze whether it would be protected under the Act? Would this be considered concerted?
So I feel like there's two separate questions, right? Whether or not it's concerted or whether or not they had, there was like a just cause provision for the termination, because you can't be sitting on a stack of 11 complaints, do nothing about it, and then suddenly the next day feel like disciplining for the first time over 30 days. I'm not sure if it would fall under concerted activity or not, but I certainly think there's a just cause provision here that would probably rule in the favor to protect the job.
Absolutely, yeah, you're absolutely right. In terms of filing a grievance and then going to arbitration, there's a really good argument to be made that, hey, you can't fire somebody for these patient complaints that you never told them about, never gave them an opportunity to respond to. There's no due process there. What about progressive discipline? Going straight to termination is pretty extreme. But yeah, in terms of concerted, so here it's the one person's post. The person didn't, necessarily talk to other coworkers and say like, hey, I'm going to make this post, or hey, let's go talk to our manager about it. But here, actually, the Division of Advice did find the activity was concerted because the Facebook post had the object of initiating or preparing for group action over the low quality of management and the issue of employee attrition. So even though the post didn't explicitly say like, hey, does anyone want to, go meet with management about this? Because the post sort of implicitly was, from an objective analysis, eliciting support from coworkers about this supervisor, they said that's concerted. That's part of the sort of like preliminary activity that we think, even if you're not actually organizing yet for that group activity, these are the preliminary discussions that you need to have to get there. They also said, we want to argue that the quality of supervision should be a topic that is inherently concerted. So even if it's just you as an individual posting about it or making a statement about it to coworkers, that should be considered inherently concerted the same way that discussion about wages would be. They also, something also to point out here is the memo said, so even if the coworkers hadn't responded positively like they did, that doesn't mean that it wouldn't be concerted, because here there still was, you know, interaction with coworkers. It was taken to elicit support from coworkers, and it's part of those sort of initial conversations you have for group action. Also, you know, they found that it was a continuation of sort of earlier conversations with coworkers about the quality of supervision. So, you know, it had that connection to group conversations, even if this itself hadn't turned into like a group conversation. And then something also interesting, the Division of Advice said, even if this wasn't protected concerted activity, we think this termination was clearly like a preemptive action to chill any potential protected concerted activity. And so there's a case called Perexel where that talks about that. So even if this wasn't protected concerted activity, clearly, you know, giving the coworker a heads up, saying heads up, you know, this is going to get this person in trouble, is trying to basically say to that coworker, like, hey, you shouldn't engage in some more activity. Yeah, so that is the gist of that. Yeah, so I mean, the general overview here is, especially if you're in a situation where you're organizing non-unionized workers, and so they don't have those just cause protections that are really helpful, and you want to help them out, either, you know, one of them gets disciplined or discharged during the organizing campaign, or you know, and you want to help them out, but also you can also want to help out the organizing effort. Filing a charge can be helpful strategically, because also, yeah, a separate thing for another day, but which a lot of folks may know, if you end up engaging in any sort of other actions, if you can show that those actions were in reaction to an unfair labor practice on the part of the employer, that gives more protection to your action. So a lot of different ways to think about using this sort of knowledge. It can be useful both just sort of then preemptively in organizing, but also then after the fact, if someone comes to you and says, I have this issue, I got terminated for a social media post. Yeah, so that is it. I don't know if I guess want to talk, if anyone has questions or thoughts. Let's stop sharing the screen.
I had a question for you, and thank you for giving it to this. Very enlightening, because actually a lot of that we're doing I'm with IBW 1220, and we're actually doing an organizing right now with Collectivo Coffee, and we just had one of our original VOC members just was terminated a couple Fridays ago for what was it? It was 15 absences over 60 days or something, and he wasn't given notice, and all of a sudden it's basically just the last example we're talking about. So it just, this feels all too familiar.
Yeah.
So, you know, under the act, like, you know, I don't know if this would translate online as well, but you know how stewards kind of have more protected speech than a traditional rank and file member. Has there been any kind of case law with that kind of translating into the digital space as well, or is that all just kind of like equal footing? You know, I don't know if stewardship is, you know, even been brought up in that kind of realm with you know, ULPs and that kind of stuff. But I was just curious if like with the salty language that you were talking about, that stuff being more protected for stewards, if there's any precedent for that online as well.
That's a good question. In the cases that I came across, I didn't see a specific example like that. That doesn't mean it doesn't exist though. So I'm curious about it. I'm happy to take a look at that and also follow up with you about that. But I think you're right that the same analysis would apply if it's a union steward, you know, posting about union activity or things like that. I think what often happens is that these cases often come up in the context of non-unionized workers, because like as you mentioned, you know, normally they would just go file a grievance, or you know, so maybe they do file a charge, but it gets deferred to arbitration, and so then these decisions end up being focused more on these non-union situations. But I think that I don't see why that same analysis wouldn't apply. But I would say that you then still want to be cautious of that right now. Technically, if the board does continue to apply this like General Motors case, then even a union steward who makes a posting about union activity, but that gets into that sort of salty language, that might be found unprotected. Then again, and so if they did go to an administrative law judge, on that they might lose initially and then they would win once it got to the board and the board overturned it. Or unless the board overturns it before then. But yeah, I don't see why that same rationale wouldn't apply in the social media context.
Appreciate it. Thank you so much again for giving today. This is very enlightening.
No problem. And thank you for organizing Collectivo. That's very awesome. I was very excited when
it's a terrific group of young folks. It's maybe the most motivated unit we've got now inside of our bargaining unit. They're just a bunch of doers, and every one of them want to contribute somehow. So it's a wonderful group.
That's very cool. Yeah, and it's good. I think they have a really good social media presence. I have noticed.
Collectivo Collective it's honestly it's so much better than like even what we do at our local level. You know, we try and do stuff like when we can, but we don't have like a full-time social media person. But they're just doing it on the side, and it's like, wow, they've got a presence, they've got a following. They're all on top of like the Starbucks stuff going around now. Why they're posting about that. They're organizing like solidarity days with them, like we're doing a letter exchange, like a pen pal thing. It's like, and this is all their ideas. Like you guys are incredible. Like, please just keep this up. So
that's amazing. Well, and I hope that they get full recognition in the contract. I know that Collectivo sounds like they're fighting it, maybe, but yeah, that's very cool. Yeah, and also good things to keep in mind if they get fired for a social media post too.
There you go. Right.
I hope they do not, but yes.
Thank you.
Any other questions for anyone? No? Well, I guess we could end a little early. Thank you so much, Elisa, for the presentation. It was so very informative, especially all the NLRB stuff. All these cases gave so much more understanding for everyone to just have an idea as to what we're going through and what changes are going to come. Again, with every new administration, everything's always changing. But yes, thank you so much. And thank you for everyone coming here.
Yeah, thanks, guys.
Thank you. Everyone have a good day. Enjoy your day. Bye-bye.
Have a good weekend. Take care. Thank you.
Everyone. There we go.
You can stop recording.
Yeah.
Yeah.